Welcome everyone, and thank you for joining us today on Level Up Law. We're here at South Carolina Legal Services. We're continuing to level up your legal knowledge on the different areas of law that we practice in. Hello, I'm Susan Ingalls, Senior Staff Attorney with South Carolina Legal Services, and I will be the moderator for the webinar today. We are joined by Legal Services Lead Housing Attorney, Matt Billingsley. Matt will be reviewing for you how to protect your Section 8 voucher in South Carolina. Please keep in mind that this will be just general information for the public and not legal advice, but it's great information that will be very useful on this subject. Keep in mind that you should always consult with an attorney if you have a specific legal issue on this or any other topic. And during the presentation, you can put questions in our question box, and we definitely invite you to do that. Matt will be glad to answer those questions at the end and potentially as we go along. Please note, everyone, the webinar is being recorded, and the recording and the slides and any important documents to go along with it will be posted to our YouTube channel for South Carolina Legal Services later on this week. And remember that information about how to apply for our free legal assistance at Legal Services will be provided at the conclusion of the presentation. You'll be in listen-only mode today, but please do put those questions in the question box for Matt. And again, thank you so much for joining us. And at this time, I'm going to turn it over to Lead Housing Attorney Matthew Billingsley.
All right. So like Susie said, I'm the Lead Housing Attorney for South Carolina Legal Services. I do a lot of different types of law, but I primarily, one of the main things I do is housing law. So what we're talking about today is going to be what we're talking about today is going to be protecting your Section 8 voucher. And it's really just going to be a general overview of what you need to know to protect your voucher. There's a few things we'll need to go over, and we'll try to take them in different sections. My hope is that will help you to understand the kind of process that you go through with voucher issues, but also that substance regarding what knowledge you have to have of what can hurt your voucher and how to maintain it. So first, we'll talk about what your Section 8 voucher is. So your Section 8 voucher, first and foremost, is where HUD pays part of your rent. Now that might, there are plenty of other types of subsidies out there or HUD-related subsidies, but the Department of Housing and Urban Development pays part of your rent. With your Section 8 voucher, it travels with you. So we're referring here to what we call a housing choice voucher. That means you have a housing choice with it. You can take it wherever you want to go. You find an apartment, you find a house, you find something within the approved size and income and rent amount, and it can go with you. And what you have then is you have a lease with your landlord. So just like if you didn't have any HUD assistance, you have a regular lease with your landlord, just as anybody else does with in the private setting with that landlord. In addition to that, the landlord has an agreement with the housing authority. So the housing authority then pays the landlord directly a portion of your rent. That can be anything from the entire amount to the rent to a small amount of the rent. But that's between the landlord and the housing authority. They have their own separate agreement. You have your separate agreement with the landlord. The housing authority themselves are the ones who monitor your compliance with the program. So when you're talking about, and what I'm going to go over here soon is about the procedure if they try to terminate your voucher or essentially end your voucher, or the process, not just the process, but the substance of why they are allowed to do that and when are they allowed to do that. We're referring to in those situations the housing authority. They're the ones who kind of monitor it. It's a little bit different than other subsidies where you might go through an eviction process or eviction procedure. It's a separate thing and a little bit different when you're talking about a Section 8 housing choice voucher. Okay. the main things you need to know as we kind of get started with it are your rights before you lose the voucher. You know, what kind of protections do you have so that they can't just get rid of your voucher and your voucher for no reason? And that is these two: notice and opportunity to be heard. Those concepts sound familiar. They essentially go down to what's called due process. You know, constitutional protections. You've got a right to your voucher and a right to that subsidy once you have a voucher. And in order for them to get rid of that or to end it, they have to provide procedural protections, which is the notice, and they have to also give you the opportunity to be heard, you know, on that issue. They can't just, well, we just decided we want to end your voucher, so that's just what we're going to do. They have to follow rules, they have to follow laws, and they have to give you a chance to defend yourself with that. So we're going to take those one at a time on the procedural part. So the first part is notice, and what you'll see here is generally what happens. The first thing you're going to get if a housing authority wants to end your voucher is you're going to get some type of notice. And what we're going to deal with primarily today are the types where you know, there's something they're alleging that you've done wrong or that you've messed up on the program, and they're wanting to terminate the voucher, as opposed to something where you've gotten employed and you make too much money to receive a voucher. We're going to go over the ones where it's essentially a violation of the program. So the first thing for the notice is the housing authority has to give written notice and prompt written notice. So that's important to know that they shouldn't be giving you notice of something you did 6 months ago or 8 months ago. They should be giving you notice when they discover the issue and sending you a written notice of their decision to terminate the assistance. So what that notice has to contain in it, and that comes by regulation and by statute, what that notice contains in it is a brief statement, you know, of why they're wanting to terminate your voucher. The important thing that I would say with that is you have to be able to, what they say, form a defense or get a defense together based on what they are alleging. That's where everything kind of starts. If you're not told what you did wrong, how can you defend yourself? So they can't just say, well, you violated this particular program rule. It needs to give you a little bit of some information of what they're saying happened. You know, think about the who, what, when, where kind of topics. You know, what happened, when did it happen? They don't have to give you write a long paragraph or something on it, but they just have to give you the idea so you know what they're talking about and can form your defense. It also tells you that if you don't agree with the decision, you can request an informal hearing. That's the next extremely important part. So this is one of the most important things to take away from it. If you get the notice, you have a certain time to request a hearing. That hearing is, and the time frame of that is in the notice, and it will tell you how long you have. What I usually see is 10 days. I usually say 10 days from this notice, you have to ask for an informal hearing if you want to have this reviewed. Okay, that is important. I've had experience with people coming to me who have missed the deadline to ask for a hearing, and when you miss a deadline, you're kind of agreeing with what they're saying. They take that as you're acknowledging that what they've alleged is true and that you are agreeing with that. So you lose your opportunity to be heard if you don't request that hearing within that time frame. And that's really important to remember. If you get one of these notices, you better write it on the calendar and you better request something sooner rather than later so that you're not running up against missing a time deadline, because that can be really bad for you. The next thing to go over would be, or just a reminder of what the notice has in it. I mentioned a little bit of this a second ago, but it should have enough detail, enough of the facts, so you form your defense. Notice that you can have an attorney. They don't provide an attorney. You don't get an attorney provided by them for you or anything like that. It's up to you to get the attorney. What's important there to note is, there are attorneys that are available to represent people in these hearings, with us at South Carolina Legal Services. There may also be some local organizations in other counties and areas that may represent people on some of those as well. The most important thing, though, is know where you can go. Don't wait until you get one of these notices before you start trying to figure out who can help you. And that's one thing that I see a lot in these types of cases, and housing in general, is people wait until they have that problem before they actually do anything or understand what resources are out there to help them. So look into that now. Be aware of us at Legal Services. If there's other people who, that have vouchers, or people in similar situations, you need to make sure, share that information with who they can go to, okay? You have to be prepared because, as you can tell, you don't always have a lot of time. You might get this notice and you have a very short window to ask for a hearing. Once you get that hearing, there's really no exact time frame of how long they have to give you that hearing. So some of them might schedule it with enough time for you to get ready. Some might schedule it really quickly. So you could ask for a hearing within a few days of that letter. They could give you a hearing within a few days of that. And so that really could shorten the time. And if you're within a week or 2 weeks trying to get everything together for a hearing from the time you got notice of this issue and defend yourself, if you don't know where to go, you're gonna struggle to get to us or someone else that might be able to help you with it. But you do have the ability to bring an attorney with you. It also notifies you of a right to request reasonable accommodations, and that's dealing with a disability. We'll go over that a little bit more later in the defense part, but that's something where if you have a disability and you may need a reasonable accommodation, they're supposed to advise you that you can ask for one. The housing authority, and this last part is really important, they can only use the grounds in the notice to terminate your voucher. What that means is they can't tell you one thing in the notice and then show up to a hearing and then have something totally different as why they want to terminate your voucher. That you wouldn't have notice of that other reason. So they can't kind of pull a switch on you and switch out the grounds. They have to follow what they put and what they gave you notice of. Okay. As I said, we're a statewide law firm, so please look into us to be aware of how to apply and how we can be contacted. We'll have a slide at the end that has that. But one thing that you also are allowed to do and you're able to do is to look at their evidence. You have the right to see what documents the housing authority has related to the hearing. You can ask to see those documents and they have to show them to you. So a lot of times people don't understand that, and you may just go to an informal hearing and they start presenting these documents you've never seen. You don't know you don't know how to defend yourself against them, or even if you have an attorney, that attorney is then having to look at that for the very first time. You can look at what documents they have in the file that they want to use against you. That's what you're able to do, and it's a valuable tool because if you ask to see those documents and they don't give them to you, they may not be able to present them at the hearing. So that's kind of a good tool you can use as a defense. That kind of goes both ways. So if you have some evidence or you have documents or you have something, a statement from a witness that you want to present, and they ask you for those, you have to show them what you have as well. Generally in the legal world, it's referred to as discovery. Here it's informal. They don't have exactly time frames and things like you would in normal procedures in court, but it really comes down to, they have to show you their information, you have to show them your information. Okay. One key part is to be prepared. So that includes looking at the information that they have, to understanding where they are coming from, or the housing authority, and what they are saying you did. Understand that you may know what happened, but the other folks in the hearing may not know what happened. So you need to prepare yourself or any witness that you may want to bring. If you have witnesses that are relevant, that they've witnessed something that happened, they were there at the time of the day in question when the housing authority says you did something wrong. Bring those witnesses or bring those documents. Have those organized and ready and together for the hearing officer. The other thing is housing authorities have to have an administrative plan. So This administrative plan is very detailed. It's a really long document that goes over their policies and procedures for everything in the program, from people getting on the program to setting the rent, income, all kinds of things. So it's a great tool to use to get information if you're not sure about a particular topic or subject. Some housing authorities have this on their website. They have it online where you could go to their website, click on it, pull it up, and there you go. Not all housing authorities do that, but even if they don't have it online, they're supposed to make it available. Most of them will have it available at their office. So you could go down before your hearing, go down a few days before and ask to look at the policy and then make some notes. They'll make copies of some of that for you, and look at their policy on informal hearings. You know, that goes into what type of evidence they look at, what their policy is, where you know, HUD gives them the ability to decide whether or not they're going to do it one way or another. And that will just give you a good idea, because sometimes, and you'd be surprised, the person at the housing authority who's doing the hearing or the person who is presenting the housing authority side of the case may not always be as knowledgeable about their own policy. It's kind of surprising sometimes that when is the last time they've read that policy, and are they actually following their own policy? And that can be a really valuable tool to use, is that the housing authority is not following what they've set out and said they're going to follow in their policy. Okay. The parts of the hearing is what we'll go over now. At this point, you would have requested a hearing. They're going to schedule it. Now, we call it a hearing, but keep in mind that usually this is happening at the housing authority. It's an administrative process, which just means it's within the housing authority. It's not a court process. You're not in a magistrate court or other court. The hearing officer is not a judge. They are just someone who is supposed to be, you know, impartial, that is supposed to review both sides of the case and the argument for what's going on with your voucher. So they act as a judge, even though they're not technically a judge. It cannot be somebody who decided to terminate your voucher or someone working under them. And the whole idea of that is it can't be the person who terminates the voucher can't be the same person to then decide whether or not they should have terminated your voucher. You know, that's kind of like having them review themselves, you know, and that's not what they do. They need somebody else to look at it. At the hearing itself, it's important to look at what happens. It must follow the housing authority's procedures. I mentioned that before with their policy guidebook and whatnot. So that is one issue there you need to be aware of. Both sides can present evidence. Okay, so this is not the same as a court. Keep that in mind. Hearsay is allowed, but should not be the only evidence. A lot of times the housing authority's policy will say that they will not rely only on hearsay evidence. And now hearsay, I understand that might be a little bit of an odd term to people. You may have heard it before, whether it's if you've been in court or even in TV shows and whatnot. Hearsay, basically, the definition of it is an out-of-court statement made by someone offered for the truth of the matter asserted. And that is just a legal definition. What it essentially comes down to is somebody else said that and they're not here. So whether it's written down or somebody, you know, saying that, a good example is, you know, the housing authority comes in and says, well, Jane Smith told us that, you know, you were using drugs in your apartment. That's hearsay because Jane Smith is not there to be a witness. So anything that they don't have someone there, the witness there, to say what they actually saw is going to be hearsay, even if it's written down, even if it's in a police report. And one thing that a lot of people don't realize is a police report itself, the part where a police officer in a police report will write down what happened, that part is hearsay unless the police officer is there to talk about it. And usually in those reports, even if they were there to talk about it, it would be hearsay as well, because they're just telling in their report what other people told them. So what other people told you or what other people are saying that are not there as a witness, that's what you really need to know about hearsay for these hearings. it can get a lot more complicated. You don't really need to go into that because those same rules of evidence and whatnot that we do in court are not really applied here at this kind of a hearing. But it is to say that most housing authorities will not rely only on that. They need some other kind of evidence to come in to support what the housing authority wants to do. With that in mind, the housing authority is the one that has to prove the case. They can't force you to prove something didn't happen. They have to be the ones to show the hearing officer, this is what happened and this is why we're able to bring this termination. You are able to present your side of the case, and you're also able to ask questions of their witnesses. So if they present a witness or they have someone that is testifying, you can ask questions of that person. So keep that in mind. You might want to think about that ahead of time before you're getting to a hearing. Or if you do have an attorney, what you're going to want to do is you may want to provide that attorney with some information about a particular witness. If you know a person is going to show up as a witness, make sure you communicate with your attorney and let them know what they need to know so that they can be prepared for that hearing. Okay. You can also object to their evidence and argue your side of the case. And that just means, you may want to point out whether during the time that the case is going on or afterwards when you get a chance to speak, you may want to point out what evidence that you're objecting to and why. You don't have the same rules of evidence and procedure in the court, like I said before, but you may want to just make a note of it to the hearing officer that I'm objecting to this evidence because it's all hearsay. They don't have any other evidence, it's all hearsay. Or, if there's some other reason that you have that you could really call into question whether or not that document or what they have is true or is an actual, real document. They might say, I gave this is the message we got from Ms. Smith. And you might say, well, that's not my phone number, Judge. I'm going to have an objection to that evidence because that's not my phone number that on that document. I don't know where they got that. So once you've had your hearing, we come to the decision. The hearing officer is required to make a decision in your case. And when they make a decision, they're either deciding to allow the termination to go forward, or they're deciding to not allow the termination to go forward. They have to give you that decision in writing. It can't be verbal. They could say verbally initially what they're going to do. That's fine, but they have to then send a decision in writing to be an official decision. It's got to be sent to the family, to the person that's on the voucher. It has to state the reasons for the decision. So it can't just be one sentence. I think the housing authority can do the termination, I'll find in their favor. It's got to have some kind of a basis of the decision. Why did they make that decision? So preponderance of the evidence is the standard of proof. That means it's more likely than not. So if they say, by a preponderance of the evidence, Ms. Smith, committed drug-related criminal activity on the premises. What they're saying is it's more likely than not, based on the evidence, that happened. That's their standard of proof. Greater than 50%, more than a coin flip is what they need to win the day. Okay. It has to be based on what is presented at the hearing. They can't go do separate research as far as to gather more facts or information. The hearing officer may want to look at what the regulations are or the policy is of the housing authority or some things like what the law is. But they can't base their decision on stuff they went and tracked down later or they tried to figure out themselves as some kind of investigator. It's all what happens at that informal hearing. So they have to give you a decision that says, I'm going to decide this way. These are this is what was said, and this is what I think was most likely what happened. And that, based on this regulation or based on this, allows the housing authority to go forward with the termination. So that way it gives you a well-reasoned decision to tell you this is why we're doing this. That way, if you want to challenge it, you also then know whether or not you have a good case to challenge it, or better yet, whether an attorney would then know whether you have a good case to challenge it. Okay. So here we are on this part. What if you go through all that and you lose? What happens? What's your next step? Generally, your next step is an administrative review. So you can ask, as I say on here, the top person. What I mean by the top person is, usually it's an executive director. There might also, in some housing authorities, may just have a board. And whatever the top person there, the top of the food chain there, is who you would need to make a request for them to not follow the hearing officer's decision. What that really comes down to, what you're asking them to do is for kind of like an appeal, to appeal that decision and have them, change it. It usually has to be for a reason, as I mentioned there, going against the law, whether state or federal, or the hearing officer went, outside of their role or went a little too far in their role. So you're basically saying the hearing officer got it wrong, or they kind of went too far. They didn't follow this part. They didn't follow this policy or something along those lines, and they made a mistake. When you come to judicial review, if they will not change the decision, you may be able to file a lawsuit in court. Okay. In order to do that, you have to really look at whether or not you have a good case. And it gets a little bit tricky. You can file it in state court if that state allows for review. Some states do. Generally, what I see is we file in federal court in that situation, and it's usually based on some type of a due process violation, or it could be based on a violation of federal law, that meaning they're trying to terminate your voucher for something that the federal law does not allow them to do. So that's where it really goes. I didn't put a lot in there to really go over the judicial review part. This is more just about protecting your voucher now. My recommendation would be, of course, at that point, seek out an attorney, get the advice of an attorney before going to that step. Federal court can be really tough. And these cases can be really tough in them, and you really need to seek the advice of an attorney at that point. And we also don't want to get too bogged down today in those kind of issues. So at this point, that kind of takes us through the procedure of how they terminate your voucher from at the level of the housing authority. Okay, we're going to go next into the substance of those issues and what allows them to terminate, what behavior allows them to terminate, and other issues to be aware of. But before I get going, I guess through that, we can check, and I don't know if Susie's seeing if we have any questions on the procedure that we need to go over.
Matt, we do have one question. I'm not sure it's really on the procedure, but let's go ahead and answer that now if we can.
Okay.
And the question is, my landlord is going through a divorce and called me and told me he wanted me to move out by the end of the month. I don't know if that's a landlord where part of the rent is being paid through a Section 8 voucher or not, but if you want to just quickly address that question before we move on, that'd be great.
Okay, and did they say it was a text message or a phone call?
Called me and told me
Okay.
that he wanted me to move out.
What I would say, and we're going to go over some of this coming up, but you also have to be aware with your voucher and protecting it, what your rights are under the regular landlord-tenant laws of South Carolina. So South Carolina is the Residential Landlord-Tenant Act, which is, I think, Title 20, Chapter 40. I think Section 27 or 2740. So Title 27, Chapter 40, and on is the Landlord-Tenant Act. But one reason you can be evicted is for the end of your lease. And when it's the end of the lease term, what they have to do is give you a notice in writing. Generally, if it's coming to like the end of a 1-year lease, or if you're on a month-to-month tenancy, they have to give you a 30-day notice in writing to terminate that tenancy. So in that situation, there's no notice in writing. The person's getting a call, say, I want you to move at the end of the month because I'm going through this divorce. They can't do that. So they can't call you and say, this counts as your notice. You have to be out in a couple of weeks. One, and it may depend on the type of situation that you have. So if you have a lease where you're renting a room and you're only there you're paying every week or every 2 weeks, that's the same kind of notice that you have to get. So whatever that term is, up to 30 days, that's the notice you have to get. If I pay every week, I have to get a 1 week written notice to terminate it. If I pay every 2 weeks, 2 week written notice. Most people are going to deal with a 30-day written notice. Key part of that is written. So a phone call does not count. It's got to be written. If that person then filed an eviction and went through, we would say, well, they did not give me the proper written notice. The case should be dismissed. So they really need to give you a written notice, but they are allowed to end the lease at the end of the lease term.
Okay, then we have one more question before we go forward, and that's on the procedural information you gave. How do you request the hearing if you get a notice?
Okay, that's a good question. Usually the notice itself will tell you how they want you to request it. A lot of times I've seen housing authorities, they're all a little different, but a lot of times I've seen them include a form in there in the notice that has where you can check a box, I want a hearing, and mail that form in or email that form in or take it down there to them. What I would recommend is that you do it in writing of some kind. If they don't have a form in there, I would, just do it on a short letter. I'd like to request an informal hearing. If you have an email for your caseworker or for the person there at the housing authority, email that. You want to be able to document it in case it comes up and they said, we never got any notice. And you can say, well, I delivered the notice to you. I called you and left a message and I sent an email and here's my email where I sent that notice. So generally it should be in writing, but don't put all your eggs in one basket. And I never really leave it up to the housing authority to hope and trust that they're going to do everything perfectly. Keep in mind that a lot of the housing authorities, if they may be having, a lot going on, they might have a lot of cases that a lot of people that they're the caseworker for, and they might be doing all sorts of different things and going all over the place. So if you just call them and ask them, they may very well forget that you've called them. So what I usually would suggest though is do it in writing and then verify it one of a few ways. So, take it in writing. If you're giving it to someone, I would usually send an email after that says, hey, I've done the email. I've dropped this off today. Looking forward to my hearing. It was my, letter requesting an informal hearing. Please let me know if I need anything else. So, something along those lines, so that if they say we never got it, you can say, well, didn't you get this email that I verified that I requested the hearing? You also may want to do that if you just stick it in the mail or mail it to them. You might want to call and make sure they got it. And also make sure to do the same thing. Call, make sure they got it, and maybe send a verifying email or an email along with the letter saying, I've mailed a letter requesting an informal hearing. This is my email to also request one. Please let me know, what else I need to do or when it might be. You just don't want to take a chance.
Yeah, I agree. Well, that's great. It looks like we don't have any other questions right now, but I do encourage everyone who's listening in to feel free to put any questions that you have in the question box, and we'll let Matt go ahead and continue now with the substantive side of Section 8 vouchers.
All right. So we've gone over, a good bit, and we can jump right into the substance. I'll try to kind of move a little bit quicker through the substance so that we can then get to some questions and go over it. But some of these slides have a lot of information, have more information on them than you might really need to focus on. But reasons for a voucher termination some are required and some are optional for the housing authority. So the required protections, the required reasons that they can go in and then put you out or terminate your voucher are if you are evicted for that serious violation of the lease. That could be, a major violation or repeated minor violation. We'll go over that in a few minutes. They have failure to submit certain consent forms, failing to do, evidence of citizenship, things like that, and having an ineligible student or being an ineligible student, conviction for manufacture of methamphetamine on the premises. Those are things that are fairly self-explanatory in the sense, if you don't do your re-examination information and documents, you're going to have a problem What we're going to focus on out of those is eviction for a serious violation of the lease. Okay. So what that is can be a few things. It can be one of the main things you're going to see is a failure to pay rent or other financial obligation. Primarily, that when you're on a voucher, you're only paying a portion of the rent, so it's failure to pay your portion of the rent. It can also be other lease violations, you know, that you violated your lease and your landlord is then filing an eviction against you. Does it affect health and safety or other residents is something you should consider. The majority of what you need to know is if I'm doing something that affects health and safety, or affects other residents, that's probably something that can get me evicted. You know, if I'm having a negative effect on their health and safety or somebody else's health and safety, you know, or their peaceful enjoyment, they call it. You'll see that a few times. And the other issue to look at is, can it be fixed? Can you cure that problem or that lease violation? And keep in mind, the termination of the voucher that's required is if you've been evicted for that. So one thing we'll kind of need to focus on a little bit is understanding how your eviction in magistrate court with your landlord can affect the voucher. Okay, so repeated minor violations can also count as a major violation of the lease. That usually involves something that is a small violation. It should be the same violation, meaning not 2 or 3 different small things, but kind of you're repeating the same behavior. You're not fixing that behavior on these small things. They can add up. So the small parts can add up to a big one if you don't, you know, fix that behavior. Okay, one example that we use, violating a pet policy or having an unauthorized occupant could be a minor violation. Now, some judges may disagree on the pet policy. You know, whether that's a major or minor lease violation. The other issues can be failure to pay utilities or other disruptive behavior. Could be a small or minor violation that would need to be added up. Okay, so pay attention to that and keep that in mind, that just because it requires a serious lease violation doesn't mean that you cannot be evicted for small things that add up. Okay. So when you're facing eviction, then the housing authority, if you get evicted, means you go all the way through, the judge says you're evicted. You know, and what I can tell you about that process to be aware of is somewhat similar to the process of getting an informal hearing or an informal review. One of those things for the informal review is whether, just like that, is that 10 days you have to request a hearing. Well, in South Carolina, if you're served with an eviction, you've got 10 days to ask for a hearing. So you can see the similarities there. You get served with an eviction, you go argue your case with the magistrate. Okay, if you win, okay, they don't have to terminate your voucher. If you go and you lose and the magistrate says the landlord's able to evict you, I'm sorry, I'm gonna have to rule in favor of the eviction, then the housing authority is going to be required to go through with the procedure to terminate your voucher. You also are required, if you receive an eviction notice from the landlord, to tell the housing authority you received an eviction notice. You're supposed to notify them as well. So the things to know about that is, you know, think about how can you avoid the actual eviction. You know, consider agreements that may allow you to move without an eviction that's filed or without a decision from the judge. Those will be marked as settled cases where the judge in state court, the magistrate who's deciding an eviction, all they're deciding is who is entitled to live there. Are you entitled to stay living there, or is the landlord entitled to get possession of that property back? So if you guys work out an agreement, most magistrates are there to respond with that. You know, that's a way to prevent the required termination of your voucher and preserve your voucher. Because there's sometimes that you may believe, I didn't really do anything wrong, I don't think. The landlord says, I think you do, and you may have the danger of getting that kicked out. You know, you may have a danger of losing in court because, you know, it's always tough to say how a magistrate's going to decide. Again, they just have to prove that it's more likely than not. So sometimes you don't want to take a risk to get evicted, and you do that, okay? So, you know, the magistrate court deciding for an eviction, as it says there, is the big issue. That's what you want to avoid. Also, if you have an attorney who helping you or representing you in the case with the magistrate, you want to let them know that you have a voucher and for them to be aware so that they can be able to advise you on that as well. If you're evicted, you also need to be prepared to defend the voucher. You know, you may get evicted for something, but remember, it has to be a serious or repeated violation of the lease. So just because the violation of the lease, or they find in the landlord's favor of a violation of the lease, does not necessarily mean that it's a serious or repeated violation. You know, what if they said, well, we're evicting you because of this, you know, small thing here, or of this pet policy. You know, and you might say, well, that's not a major lease violation. You know, so maybe I don't need to lose my voucher. The other thing might be, like when I mentioned the question earlier, if you're getting evicted for the end of the lease term and your lease has run out and you haven't found anywhere to go yet, and the judge says, well, I have to fine for the eviction. Well, that's not an eviction for a lease violation or a major lease violation. So that should not then result in you losing your voucher as well. But one thing you might want to do is be, like I said, be prepared to defend the voucher if you are evicted. You know, be aware that that would be coming next in that situation if you're going to defend it. That can also be that in the state court with the magistrate, if you disagree that the judge got the law wrong, you might do an appeal. You know, so that case might stay under appeal, and that might pause the time then that you have, or that they have to actually do the termination of the voucher, or it might be a reason that they hold off on it. So, and keep in mind that state law does apply. And what primarily that means is under state law, if you violate the lease, they got to give you a notice in 14 days to fix the problem. That's a big deal. A lot of landlords don't follow that, don't really understand it, or don't know it. And that can really be an effective way to help you get an eviction dismissed, or to fix a problem, or to show that you shouldn't have your voucher terminated. Okay. Now, going over the optional ones. When we go over the optional ones, you know, there's several things here, and I'll hit on. We're going to then hit the primarily the ones that are really important and that I see more than anything else. You know, violating family obligations. We'll talk about that a little more in a minute, and it's pretty general. Most of these self-explanatory. Drug-related criminal activity or alcohol abuse, the criminal activity. Again, you see that language of threatening health, safety, or right to peaceful enjoyment. If you've owe money back to the housing authority and you're making a repayment agreement and you violated that agreement, could be a reason. Having unauthorized people live with you could be another reason. And obviously, there's more to it. The regulations on this stuff lays out more reasons they're allowed to terminate. But I don't think that for the purposes of today that we really need to go into those other ones. You're not going to see the other ones pop up too much. And there are just, you know, various reasons. The primary ones that you need to be aware of are the ones that we're talking about today. All right. So violations of family obligations, that comes in when you're doing a recertification each year, you know, or if you're doing a change in your income or household size that you need to report. If you've given false information, using the premises for something other than a residence. I've seen people that have been, you know, almost using it as a business, selling things out of the unit, which could be a violation. You know, you have to notify the housing authority if your household changes, the makeup changes, if you're getting any other subsidy, if you've left the unit or no longer are in the unit, you know, essentially as they call abandonment. Housing quality standards comes in, which just means you could have a violation of your voucher if you're not paying your utilities, or you're damaging the residence that you're living in beyond normal wear and tear. Now, the thing with utilities that you want to be aware of is with the housing authority, they pay part of your rent. They also give you a utility allowance. So sometimes they're paying you a check for utilities, for part of the utilities, or that's factored into how much rent you owe. Because they do that, they expect you to then pay the utilities. And if you can be terminated from the voucher program if you're not paying your actual utilities or having them on there. Generally, I find they're not trying to do that when people are having an issue or struggling, but they're trying to make sure somebody's not getting the subsidy and maybe living somewhere else or doing something of that nature. So it's just something to be aware of. Usually that can be worked out or avoided You know, as long as you're aware of it, stay in touch with your housing authority. Okay, so drug-related criminal activity generally should be by a household member. The elements are manufacture, sale, distribution of an illegal drug, possession with the intent to do those things. Mere possession is not enough. The reason I bring that up is if you or a household member gets arrested, charged, and then convicted of simple possession of marijuana, let's say, you know, that conviction, then they could use that to say, well, this is what you're convicted of. The argument back to that is the definition in the regulations just says that I have to either be selling it, distributing it, manufacturing it, making it, or using it, or I have to possess it with the intent to do those things. So the idea being, if I have an illegal drug on me that's in my possession, but I'm not intending to use it, you know, what if it was you can imagine, what if your grandmother has a voucher and a local child or somebody had thrown some drugs or discarded some drugs near her residence. She picks them up with, you know, and has them on her with her intent maybe to throw them away or dispose of them or to even contact the police about them or something like that. And somebody sees her with them, you know, that would be a situation where she shouldn't get her voucher terminated. She's not actually participating in drug-related criminal activity. So it's just something to be aware of. It just adds a defense that you may have if it comes up. Okay. One thing to also be aware of is they don't need a conviction. They don't even need an arrest. You know, they just have to have some kind of evidence. But even if there is an arrest, they can't use that as enough evidence of that's something that actually occurred. A conviction, on the other hand, of a particular crime does count. So keep that in mind. Other criminal activity by a household member, it can be violent criminal activity that occurs anywhere, because then you as that person as a violent person could be essentially a threat to others. Criminal activity that threatens the health, safety, or peaceful enjoyment. Now make sure it says to residents or those in the immediate vicinity is how they usually look at it. So that means people immediately beside your residents, your neighbors, those kind of things. Or in an apartment complex, people living right by the complex or others living in the apartment complex. As I said, the arrest or charge is not enough. The housing authority, again, has the burden of proof. But keep in mind, if you or a household member are convicted of something, that's all they need. They don't need anything else other than that conviction. You may need to be aware of that in the event you or someone else is charged with a crime. The type of crime you're charged with or convicted of may make a difference on whether or not you lose your voucher. So that's something also to be aware of. If a household member is charged with a crime, they have an attorney, public defender, or a private attorney. They need to tell that attorney what they're doing and whether or not they've got a voucher, because that could come up and be important. Okay, unauthorized occupants. This comes up a lot all the time. I've got, you know, cases right now with these issues of unauthorized occupants. It's a very common thing, and it's most people, a lot of people that I see have this issue. It involves when somebody's living in the home that is not on your voucher. Kind of like how it's on with your lease. You know, you don't have you're limited people on the lease. You have to add somebody to your lease. Same way there with your voucher. They don't want other people, you know, getting the benefit of the voucher that haven't been added. You know, there could be people that are living with you that are not able to live there under a voucher due to certain rules. It could also be that the person who lives there is making money, and that would affect how much money you were paying in rent and how much HUD is paying on your behalf. And so that is where the issues come in. You must get the approval to add the people. Keep in mind, the things you have to look at is, do they actually live there? Sometimes people will, you know, housing authorities will make assumptions. Well, they live there because somebody sent a letter to them there, or, you know, something like that. You know, you might have a friend whose mailbox got messed up and hadn't been fixed or replaced yet, and he temporarily asked if he could send some mail to your address so that, you know, so that he gets the mail. Or, you know, you could have a friend who says, can I have a gift or something that I've ordered sent to your address because I don't want, you know, my child to see it and I want it to be a surprise for the birthday. Well, that getting sent to your address with that person's name does not mean that they live there, but some housing authorities will try to say, well, that means they live there. So you need to be aware of that, be able to show some evidence that they don't. Make sure you know what the guest policy is for the housing authority. A lot of times they have a guest policy of this is how long somebody can stay with you before you need approval from the housing authority. A lot of them have 14 nights in a year for that person. Some of them have it for, a shorter amount of time within 30 days or X amount of time over the year. So you just need to make sure you can find that in the same place we talked about before, which is the administrative plan. Okay. The other thing to keep in mind is, could they be added to the household? Can you add those people to your house or to your voucher? That's one way to explore it, but it's better not to take the chance. Make sure that if you have somebody living there, that you're getting approval for them to be there or adding them to the household. Okay. They often will request proof the person does not live with you. They still have the burden. They still have to provide the evidence and prove that that person is living there for the hearing officer. But just keep in mind, is there an easy way to show that that person is just a visitor? They're not there. If that person lives somewhere else, they got a lease. If they got a utility bill, they have their name there. If their driver's license shows a different address that they live at, if they live with their mom and their mom can verify they live there, it may be frustrating sometimes and you feel like, why do I have to do this? Why do I have to do that? But at the end of the day, sometimes if you've got an easy way to show them this person doesn't live there, that might stop it before you even get to the informal hearing. Sometimes they will meet with you at your request to kind of discuss it with you in your caseworker. So keep that in mind as well. Common defenses is what we'll go over now. What you need to understand about, with these issues, what kind of defenses can you have? What can you argue? How can you get around these things? One of them is, and they're listed here, we'll go over them kind of one at a time and kind of just hit the highlights of them. But there's mitigating circumstances, just means there's other things that the housing authority should consider that might allow me to keep my voucher. If it's a violation that's really harmless, it's something small. Maybe somebody was staying with you or you were, whether it's a child or whether, somebody else stays with you for a while, and if they don't have any money, and if you would have added them to the household, you would have paid less in rent. So there's no real problem with the housing authority as far as you weren't overpaid money by HUD. It's still not an advisable thing to do, but just keep that in mind when that's something when we say harmless violation. Things like removing a household member, a reasonable accommodation that we'll go over a little bit, with a disability waiver, whether or not the housing authority has kind of waived that issue you had, and the Violence Against Women Act, sometimes called VAWA. We'll talk about that just a little bit. Okay. So certain mitigating circumstances that we usually go over is the housing authority should look at a family situation, their whole situation, the seriousness of the violation, how bad was it, the extent a family member is involved in the act, as opposed, if they were only slightly involved or not really that involved in the act. They can look at the disability of a family member, the effect of termination on the other household members. And that's an important one. How is this going to affect everybody else? How is this going to affect the rest of my household? If there's another adult in the household who's, let's say it's a mother, a 22-year-old son, and, a 10-year-old and a 6-year-old as well. And the 22-year-old son does something wrong or messes up, and they say, well, how is this going to affect these other two children and the mother if we put the whole family off of the program? And they're supposed to consider that. What will happen? What will be the effect of it? And there are significant effects to that. They could make them homeless. That could mean that those two children may not be able to stay with that mother if she becomes homeless. And does DSS get involved? You have situations where the Department of Social Services steps in and those children go to foster care. That might be something to keep in mind from a housing authority perspective of what snowball effect this could really have on a family. So that brings us to the next thing of removing an offending family member, household member. So that's one way that might, solve both issues. The other family members who had nothing to do with the problem, usually that you see that a lot with criminal activity, but they may be allowed to stay. Be prepared in that situation if something happens to make a plan. Have somewhere for that other person to go, or to show that that person went somewhere else and they're not coming back, and you're asking to remove them from the household. So also check the policy on that. Again, the housing authority does not always remember their own policy. So, go and review their policy, their administrative plan. See if they have, usually what they'll do in an administrative plan is they'll say, here's what HUD says, maybe what a regulation is, and then below that they'll say, North Charleston Housing Authority policy, like for North Charleston or for some other whatever the housing authority is, our policy, and then it will say what their policy is. That's again a powerful tool to understand and know what they will do. If they're saying, if we can, we'll remove a offending family member, and then you're getting resistance from a caseworker or hearing officer, that can be valuable to say, well, wait a minute, your policy says you will do this, and that can be an effective tool. Okay, think about how the termination can affect the rest of the family, and be able or prepared to share that or discuss that with the caseworker or the hearing officer. Okay. So for harmless violation, is something usually small, such as you didn't give them the eviction notice that you received. That can be fixed pretty easily in providing it to them when you realize that, or when they ask for it. It doesn't usually have a bad effect on the housing authority. I mentioned the family member with no income before. So just keep that in mind. Those are some defenses to it. Okay, reasonable accommodation. And when you say reasonable accommodation, it means someone with a disability that needs a change in a policy or a procedure or something along those lines, so that they can participate in the same way, or comply with a particular requirement. So you have to request that. It won't just be automatic. You have to request it in writing. They can move forward if the family cannot comply, even with a reasonable accommodation. So if they can't really, if there's a reasonable accommodation that won't fix the problem, they might still be able to move forward with a termination. But it may involve, think about something with a recertification, someone who has difficulty getting around and getting to the office. Maybe they could, mail the documents to them to sign or whatnot, or maybe they can make some other accommodation. So that's something to be aware of and to be on the lookout for. And the key there, you have to request it, and it has to be in writing. Okay. When we talk about waiver, we're talking about the housing authority knows about the violation, but they don't really do much about it, or say they move forward on approving a new lease, or they recertify you after the violation. They waited a long time to do anything about the violation. That's where you can say, look, they've waived that claim. This was 6-7 months ago. I talked about it with them. Then I did a recertification. They approved the new lease, and now they're trying to say they want to kick me off the program for it. That doesn't make a lot of sense. They just waited too long. It's a good, easy way to say that. Okay. The Violence Against Women's Act is something we really need to hit real quick, and that is protection from voucher termination related to the following: domestic violence, dating violence, sexual assault, or stalking. Okay, so those things can protect you even if it's from a family member. So if you're in a household and if you have let's say there's a couple that are on the voucher, and they get into altercation and there's some domestic violence. Okay, the person who is the victim cannot be put off of the program because they were a victim of the domestic violence. The other person may have committed, a criminal activity that threatens health and safety, and they can then split that voucher and terminate the other person, but they can't terminate you as a victim. Same way if you were just the victim of, with a guest or someone else or whatnot, they can't generally do that. There's only certain situations they could do that. But as far as in the world of the voucher, they're not able to terminate, and that can really be a defense to that. And I've had that happen before where I've used that as a defense. But as a victim, you notify the housing authority to get the protection. They usually ask you to fill out some paperwork. The information is supposed to be confidential. That essentially what it does is it acts as a defense to a serious lease violation for termination. And you might get the landlord trying to terminate you, and the landlord may not be exactly tied to VAWA in the same way that the housing authority is, but that's just an element to be aware of and to deal with as a defense to kind of help you keep the voucher if you find yourself as a victim in one of those situations. As I said before, a pending household member can be removed, and you can move for your safety. So it might also allow you to break your current lease because you need to go move somewhere where the perpetrator does not know where you are, or the abuser does not know where you are. A few key things that we really need to hit, I think, here, because that pretty much goes through the substance of it. But I think a few key issues we need to go over is reporting changes to help yourself. One other pitfall I see for people, and this is kind of prior to getting to the part about a voucher terminating or being terminated, is tell the housing authority when your income goes up or down. Notify the housing authority quickly, follow up with them, you know, make sure, like I said before, follow up in a couple of different ways to try to make it clear that you have reported a change, because that may come up later and be really important. When you're following their requirements, make sure you know what those requirements are. Make sure you're aware of what's required of you to report a household change, meaning a person moving, leaving, or wanting to add someone, or your income that goes up and down. When your income goes up and down, that affects your rent, either the amount you'll owe, or it affects whether or not the housing authority is paying enough for you to be able to afford. So both of them can have a bad effect. You're supposed to tell them in a certain amount of time, but if you don't report that you lost income, they're not going to go back and fix it for those months you didn't report it. And so you might end up owing rent to the landlord that if you would have reported your loss of income, you wouldn't be owing, because the housing authority would have fixed the amount and would have paid that amount for you. But when you've made the mistake, that really puts you in a tough spot. Again, too, when you don't report your income increasing, that changes how much you pay, and that results essentially in an overpayment. So that becomes an issue as well that you have to deal with. And you just really need to, I see a lot of people getting into problems because they did not report the income, or maybe they said, well, I went by and mentioned it to somebody, but they didn't confirm it. So with an email or something, they could go back and say, here, see, this is when I reported it, okay? The reason it matters, like I said before, you can't get the benefits of the rent change. I really don't assume housing authorities are always going to do everything perfectly. You know, they're human, they're people like everybody else. They have a lot on their plate like everybody else. So just make sure that you can verify things and information you've given them. If they make a mistake, that's on them. If you make a mistake, though, that's on you. So that's why we highlight, you know, you can end up owing rent that you can't afford. You can end up having to pay back the housing authority, which makes it further have a further difficulty for you, where if you mess up on a payment plan, you could then lose your voucher. So it could have you know, this domino effect you don't want to create. You know, it can also lead to eviction. I've seen people get behind in their voucher, or they didn't report their decrease in income or loss in income, and then it came up that they owed this money to their landlord and they couldn't pay it. And so then they're getting evicted for rent because they didn't report it properly and on time back when it happened to the housing authority. Okay. Well, that leads me into the next thing, and the real important thing to take away from a lot of this is communication. You know, keep in touch, know who your caseworker is, know their contact number, their email address, or at least an email address to the housing authority if they have a general email that you can communicate with. As we've said before, everything, document that communication, whether you verify it in a text, an email, a letter, however you do it, and always keep a copy of that communication for yourself. If you send a letter, make a copy for yourself. An email is easy to bring back up and to print. Okay, so make sure that you have some way to verify that. Don't be afraid to follow up with the housing authority. Don't be afraid to check on them. That does not mean call them 10 times in a day or something like that. But within reason, you know, don't be afraid to follow up, because you don't want to assume, well, they got the information, they're just going to take care of it. If somebody over there has made a mistake or whatnot, it can be annoying and kind of very difficult to unravel that mistake. And usually staying in touch is a really key component of that. Okay. Also, like I've said throughout, we've seen this kind of peppered throughout, is the knowledge. Knowledge is a crucial thing. Know your lease and rules, but also know where to find information. You don't have to memorize everything. It's not some test. You're not in school or whatever for it, but you need to know, where can I find information on this issue I might be having when it comes up. So know how to look at the administrative plan for the housing authority that has your voucher. You know, look for information you may already have. You might have, when you first got on the program, have an orientation packet, recertification information, and that might have some documents that really help you that you may not have needed then or looked at. But you save those in a folder or whatnot, and you might have to go back to them and go, okay, well, this is helpful. Now there's an issue that you may need to look at. Okay. Ask an attorney or attend other information sessions like this one. So even if you don't need, at that time, you're not going through a voucher termination or something like that, it might be helpful to still look and keep yourself up to date on information sessions like this, so that just you're aware of what's going on and what your rights are, because that's the best way that you can help protect yourself and really protect your voucher. Okay. That pretty much is the presentation. What I wanted to do, Susie, is see, is there anybody with questions, and what areas do we need to go over a little bit more?
Well, wow, Matt, that was a lot of great information, and we do have a couple of other questions that I'd love for you to answer. But before you do, just in keeping with the time that we have is limited, I want to just go ahead and give a little bit of information about our next Level Up Law session and so forth. And of course, I want to thank you for an excellent presentation about Section 8 vouchers. This was great information. And let me also thank all of you who joined us today. We really do appreciate your interest in these webcasts. I want to make sure that everybody knows that we do these every Tuesday at noon. It's a series of free legal events, and you'll be able to find this presentation and all the previous Level Up Law webcasts on our YouTube channel. You just go there and search SC Legal Services and go to our Level Up Law playlist. Be sure to like and subscribe and sign up for those alerts while you're there. Just give us a day or two to get this one uploaded, and you can listen again and look at this great information on the slides. Okay, if you have an issue and you need legal assistance on this or some other topic that we represent folks in, we want you to apply for our help. And you can see here on your screen how to do that. You can apply by telephone. Our intake specialists are standing by Monday through Thursday, 9 to 6. You can also apply online at our website. And remember, we have a lot of great online resources that are very informative on this and other topics. Now, thank you again for tuning in today, but I want to let you know that next week, be sure to tune in when we will be talking about U visas. And but because our office will be closed on Tuesday next week in observance of Election Day, that presentation will be pre-recorded and it'll be posted directly to our YouTube channel. So just keep that in mind. There won't be any registration or questions available for that. So before we conclude today's webinar, I'll ask Matt to answer these last couple of questions. Hang on just a second.